The Law Report with Karen Key.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And before we begin, a reminder that there's a list of available documents on the Facebook page, Law on SAFM. You can post a message on Facebook if you'd like any of those, but please also remember to include your email address so I can send them to you. If you don't have access to Facebook, you can mail me on law@safm.co.za and I'll send you a copy of the list and you can choose what you'd like. Well, I'm joined once again this evening by attorney Nicoline Schoeman-Low, a director of Schoeman Law Inc., attorneys, conveyancers and notaries public practicing here in Cape Town. Nicoline, hello, welcome back to the show. It's been a while because it was a bit of a delay from you coming back now. You've been having a fabulous time away. You've been actually working though.
Yeah, time away, a little bit of work and a little bit of pleasure, but it's always great to be here.
You need a break every now and again. If you have any questions, you can call us now on 0892 10 2010, 0892 10 2010. And before we go to your calls, which I see are already coming in, we've just got a few emails here. This is from Lucky, who says, what are my legal rights if a writer uses my name, family name and explicit information in a book which is having some serious implications without my consent? The main concern here is the use of the name and family name in the book without the person's concern. The book is currently on sale to the public. Can one sue the author or the publishing company after applying for the restraining order with the High Court, irrespective of the contents? Can one also complain with the public protector for the violation of the rights of an individual, for example, the rights to privacy, or the use of someone's real name for your own benefit from the sales proceeds? Does the Ombudsman come into the rescue of the rights of individuals here? I'm not quite sure what the book is or what it's about, but yes, what does Lucky have? Has he got any rights in this regard?
Well, this is a classic intellectual property law matter, which really means that it's a question of copyright and those kind of infringements. Of course, I'm not an intellectual property attorney. That's a very specialist field in law. And there are a handful of firms around the country that do specialize in it. But, from my basic knowledge back from my studies in my LLB, this definitely has affected the rights in terms of the intellectual property laws, and that there will be recourse in terms of that. This is also, besides the intellectual property rights and royalties and all these other things that come from that may make up a damages claim, so to speak, or a claim. There's also the aspect of consent that wasn't obtained, and potential infringements in privacy, and we don't know the contents of what has been published, maybe even defamation of character. So there may be quite a few arms to this, but I think a good point of departure would be to see a person who specializes in intellectual property, and they are often very versed in the aspects that sort of are associated with these kinds of infringements.
It wouldn't pay Lucky to try and do this himself. If you need somebody who knows what they're doing.
This is quite complicated because obviously if this book is on the bookshelves out there, it means it has probably gone through quite a reputable publishing house, which has, quite bluntly put, a few big guns behind them in terms of a law firm. So if you take them on as a private individual, you'll quickly get sucked into all the legal jargon and all the legal terms and all of these things that may become very overwhelming for an individual. So it's very much worth his while, particularly if we're talking, from the sounds of it, we may be talking about a substantial amount in a claim, not just the interdict to stop them from distributing it further, but also the ancillary damages claim, which may be made up from potential royalties or defamation and all these other things that we were talking about.
So get yourself a good intellectual properties attorney.
Yes.
Okay. Right. Then Oscar sent us an email, but also sent an attachment and says, I had this agreement as attached, which I have here, and says, basically what happened was that it was a bit confusing. I'm not quite sure. They actually had a truck and they leased the truck to another company.
You see, what confused me when I read this email was really that the agreement, or the one-page document that was attached purporting to be an agreement, states that it's a joint venture agreement. It
Yes.
doesn't state that it's a lease agreement or anything like that. It just says that this person brings the truck and these are the associated rights and obligations from the other party. This is how we're going to come together to make this a profitable business using this truck. So, there's just in the email, it says that there's been some breach of this agreement by the other party, presumably that they haven't paid for the fuel and the expenses.
But besides that, I mean, this Oscar apparently was the owner of the trailer.
Yes.
And this other company's now changed the ownership of the trailer into their name, which, I mean, I'm sure
Exactly.
you can't do that.
No, I mean, anyone who's recently tried to transfer even a motor vehicle, a car, or a trailer or a caravan or anything like that from the owner as it currently stands on the documentation to a new owner will know that it's quite a cumbersome process.
It is.
And if the original owner or the authentic, the real owner isn't present at the transfer, then this is very serious fraud that has
That's what he said.
taken
Does this not constitute fraud?
so, the illegal transfer, of course, can be challenged in terms of the fact that it's fraudulent, and that can be done through the South African Police Services. As for all the damages claims that may arise, or actually getting the trailer and the vehicle back, that will have to fall through a civil process, which means you need to get yourself an attorney. The only comment I'll make on this agreement that it's really, I suspect that it wasn't professionally done,
No.
and that it's really very, very poorly put together. It's very confusing. So really for us to dig into and say, this is what you can do and what you cannot do is really difficult for us. A, we don't really have all the background, and B, this agreement is really very ambiguous. So it talks about a trailer and a truck and a vehicle and some costs that will be paid and security that will be given, and there's an allegation of breach. But we don't know to what degree or what the person wants. There's even no out clause or termination clause in this one-page agreement. So I would just plainly advise this listener to get yourself an attorney who can launch the
Unravel it as
necessary actions to A, get the vehicle and the trailer back, and to cancel this agreement. End of story.
Right, okay, we have one more email to go, so if you'd like to call in with your questions, 0892 10 2010. Right, this is from Malcolm. This also sounds quite horrendous. Malcolm says, I have the following question. I booked a ticket for overseas with a certain airline for 25th of May. 2 weeks later, the travel agent told me that due to unforeseen circumstances, the time of departure of my flight would be changed. The airline offered me a full refund and a choice to change my date to a week later for free if this was inconvenient. I told my travel agent that I needed time to think about it. She advised me that the best option was to cancel, get a full refund, and book later. Last week, I decided that I would cancel my ticket, obtain a full refund as stated, and book later when the dates would go back to normal. I subsequently told my family overseas and my new employer that I would not be coming in June. Last week, before I could email the travel agent, I received another email advising me that the flight times had gone back to normal, and I would either have to fly on my original ticket as booked or pay a penalty to change to another date to cancel but not obtain a full refund. My question is, am I legally obliged to pay a penalty to change the date in the above circumstances? And then he emailed again and said, further to my email, just to clarify, I was told by the travel agent that the dates would only go back to normal in July. Therefore, I informed my new employer overseas that I would be available in August, and told my brother overseas that I would see him in August, and he's now left on holiday. If I leave now, I won't have anywhere to stay or to work. I changed my plans due to what the travel agent told me. Please advise whether I must pay a penalty to change the date.
You know, it's always difficult with airlines because some of them are based here, some are not. But the Consumer Protection Act does govern any transaction that takes place in the country. So by measuring it to that, if you've paid in South African rands in South Africa for a plane ticket, regardless of where it's going, then the Consumer Protection Act applies. Now, the Act is very clear on a number of things, the most relevant in this case being the issue of double booking or of changing in flight plans and ticketing and so on. And that also applies to, of course, things like theatre and any other ticket that you would buy. So firstly, there is protection in terms of double booking or changing, and there are certain regulations that need to be adhered to. So this could be something that could be reported to the Consumer Commission. However, that takes months, weeks. It won't be resolved before August. Let's just put it that way. So that is an option if this doesn't get resolved. But in most instances, paying the penalty, and of course, these guys rely on it, that it's cheaper and more effective for you to just pay the penalty and let's just resolve it quickly and easily.
But they were the ones that kept messing him around with the dates.
Exactly, and it does happen, particularly if the weather or some condition in the destination country is of an unstable nature, whether it's permanent or intermittently. So in a nutshell, the listener must decide how much is the penalty, and usually it's not a substantial amount.
It's not cheap normally either.
No, it's not cheap either. But you need to weigh that up against a complaint at the Consumer Commission, for example, that may take weeks and months to resolve, which may result in you completely postponing your trip until, later the year.
What if he paid the penalty but told them that he was paying this under sort of duress, effectively, and he would be reporting it to the Consumer Commission?
Of course, you can do that.
So if you pay it up front, it's not going to negate your claim.
But I think then it needs to be coupled with some communication to them to say to them, I have paid this not in agreement of your terms, but just to get this matter resolved, and I will follow the channels following this. Furthermore, your travel agent should, as if nothing else, as good business practice, assist you in resolving this. They usually have contacts within the airlines on a much higher level than the normal consumer on the street. So that's a second avenue. If they refuse to assist, then of course their supervisor. So what I'm trying to get at is really to say, speak to the travel agent or the immediate superior or the owner of the travel agency if it needs be, to try and resolve it amicably. Or in the alternative, try and speak to the airlines. They often have call center agents and these guys who are also able to assist. And sometimes if you are able to go a level higher up, you're able to negotiate these kind of terms. That to me is a much more practical approach than to say, issue a letter of demand or report it to the Consumer Commission, because all these things are going to take time. And it's not going to resolve the immediate crisis that the listener is facing.
And then, and this is just me because I'm neurotic, but if you talk to anybody about anything, I would always follow it up with an email saying, regarding our previous conversation, this is what we discussed.
Yes,
and so that you've got a copy, you email it to them.
Trail.
Yeah, the paper trail is the big thing.
Because remember, this is just step one. You're going to try and resolve it either through your travel agency and or the airline concerned directly. And if followed up, build that paper trail. Because if that fails, you'll end up paying the penalty because you want to now travel at a predetermined time, which suits you and which, of course, I hear employment is also at stake, which, accommodates all these factors. And if that doesn't help or doesn't resolve the matter, then you want the recourse to the Consumer Commission. And then you'll need as much evidence as you can.
And all those bits of paper.
Present. Yes.
Love bits of paper. Right, we've got some calls on the line. Teresa in Cape Town, good evening. Teresa? Hello, Teresa, are you with us?
Yes,
there you are. Hello, found you. Hello. How can we help you? Hi, you phoned in last week and I said we're going to call you back tonight when Nicolene was here because Teresa wants to talk about your favourite topic.
Can I continue?
Yes, so you carry on. You want to talk about Nicolene's favourite topic.
That's correct. Thank you so much, Nicolene.
Hi.
Both my parents, I'm sitting with this dilemma, both my parents passed, respectively 2001 and 2008.
Okay.
In 2010, the eldest sibling registered our parents' will as he was placed in the position as executor as per the last will and testament.
Mm-hmm.
But of course, we were, the other three siblings were unaware of his movement concerning this the last will and testament because there was no communication from his side, and he refused to communicate with any of us. Mm-hmm. They only learned that he was busy with this with an attorney in 2012. Now, last week, I then received, and this is after much, correspondence to the masters, from the masters, with me going to the master's office, getting in touch with the attorney via telephone, questioning the attorney. We weren't happy with, the attorney. I also then lodged a complaint with the Law Society. So there was a lot of correspondence. However, last week, I received a letter from the attorney confirming that this particular executor, the eldest brother, has been removed as, of course, he didn't comply to what the master requested of him. Now, in this letter, since my father passed away, that was in 2008, the youngest sibling, moved in. Whilst my father was alive, she moved in. And then, of course, after his death, she paid a few months of the rates and the rent. And then she stopped because she paid it to the executor. I understand that it was supposed to have gone into a trust. We're not aware of what happened to that money. Then, in this letter that I received last week from the attorney states that the youngest siblings were not liable for the rent payable, as this was payable by the estate after the death of your late father, as said. But is that correct? Is it supposed to come out of the portion that we are supposed to get, that, the other siblings are supposed to get, seeing that she occupied property?
So
is it correct that she wasn't liable for paying the rent and the rent?
Well, it depends what the will says. If the will has established, by example, a trust, and the property is then registered in the trust's name, and one or more of the siblings can stay there, it may be the responsibility of the trust or the estate late to pay for the rates and utilities and all the expenses.
Sorry, Nicoline. Now, at the time when I spoke to the masters, there was no trust. There was no trust.
You mentioned a trust. That's why I brought
she said
it
she
up.
thought the money should have gone into trust because the sibling was paying it to the executor, which was the older brother. Now the money seems to have disappeared.
Well, what you'll have to do is you'll have to get your own attorney to get a copy of the file at the master's office, which will include the will, as well as the liquidation and distribution account.
I've got the last will and testament, and I also have
the L&D.
I also have the L&D list with me.
Yes.
And that was the first L&D.
Yes.
The master had since spoken or sent the executor and asked him to let me just see. To ask, the master asked him to forward a new list, a new L&D list, because he wasn't happy with what was, on that list. No rent were included, and as the master said to me, if the rent is to be collected, there also won't be a shortfall on the L&D, and
course.
because now the heirs have to pay the shortfall, the cash shortfall.
This is a very sad situation, but it's unfortunately something that happens more often than I think any one of us would want to see it happen. And I'm actually dealing with a similar kind of estate at the moment, where one of the siblings has done something. Well, I'm not saying this sibling has done it. Allegedly, he's done the same thing as the estate that I'm dealing with that has been proven. There's been some misappropriation of funds by the executor. During the deceased's lifetime, he was also the curator for the deceased, who was quite elderly and frail. And the fraud and the misappropriation started in the life of this person, and it just simply continued shamelessly as he was administering the estate. So when this kind of thing happens, what you need to do is one step that you've already achieved is relinquishing, or for lack of a better word, firing the existing executor, and then appointing a new person. That new person what I do when I take these appointments is I actually get a forensic accountant on board, and we go through each banking account. We go through each bank statement, and they do a full forensic financial audit, and they see where the money has gone, essentially. And once you can determine the amount that is missing and who was in control of it, which would have been the executor, then you can start preparing your case to claim from the executor. This is quite an old estate, so I would really recommend that you make haste and appoint yourself someone that will deal with it on this basis. That you can
Also,
see where the money is gone.
One last thing. An affidavit was also signed by the then executor
Yes.
in 2013, 14th of March 2013, stating that the heirs have received the inheritance due to them and all the creditors have been paid.
Oh,
And
my word.
we are still sitting with this, matter that hasn't been backed up.
That's an additional issue then. That's perjury. That's and it can even be fraud. It's pretty serious. So I think make haste, appoint a forensic accountant or even an auditor, but someone that specializes in, as the accountants call it, looking for the money.
Yeah.
So that you know where it's gone, who was in control of it, what type of amount are we talking about that is exactly to the cent that is missing. And then if you go this route, you need to pull out all the stops, as they say. Every document that was misrepresented, every fraud, every affidavit that purported some set of truth that turns out to be nothing more than a blatant lie. All of that will have to be brought in, and this means that you'll pursue the eldest sibling
It's criminal charges.
in his personal capacity, and there will be a criminal element to it. So in all likelihood, this will have jail time as a repercussion, not just a case of repaying the money.
Yeah, because
This is serious.
I actually let him know via text message, and I said to him, I'm aware of the affidavit that was signed, and is he aware, and I'm sure I said you are aware of, the consequences. And he just said, don't speak to me, don't phone me again. So yes, there is no correspondence, there is no communication. He refuses to do that because, we suspect that there is definitely underhandedness happening there.
Will this attorney be willing to assist you in any way, the executor's old attorney? Or
No,
not really.
No,
She's bound by attorney-client privilege in any way.
Yeah, no, I'm not happy with the attorney. So if I'm not happy with the attorney, but the other two siblings have now sort of come to